All right, well, let's get on the record then. This is 25CV006709, and it is Rutherford versus Robinson and several other defendants. Let's figure out who is here in court and who we've got online. And then we've got about 2 hours, if we need that much time, to sort out what's going to happen this weekend. So who's here for Ms. Rutherford?
Good afternoon, Your Honor. Justin.
And this would be Ms. Rutherford.
Ms. Rutherford, yes, sir.
Good to see you again, Ms. Rutherford. Mr. Kenner.
Good afternoon, Your Honor.
How are you?
Fine, yourself.
My understanding is that you represent Ms. Robinson, and I see there's a Bobby on Zoom. That would be Ms. Robinson. You now represent Mr. Pym. I can see him. He's on the screen. You represent E32 LLC. And you have a big portfolio. You represent Harold's Ice Bar,
Correct.
Which would be a business venture between Ms. Robinson and Mr. Pym.
Correct.
You do not, nor does anyone, I believe, represent Harold's Enterprise.
Correct.
Okay.
In
fact, no one is here for Harold's Enterprise, sadly. Everyone is, because that was sort of the original LLC, but it was a defendant added by Mr. Edge, but represented by no one and is in default, I think.
Correct.
Okay. All right. Great. We are here a few days early for a hearing on a new emergency TRO. We had a TRO hearing a long time ago. In fact, I have my stuff back here. Yes, you guys were going to mediate. I have it in red. Mediate. I'll hear from you in a second, unless you've resolved things.
No, sir, it was a preliminary injunction.
Okay.
Yes, sir, the hearings.
We had a hearing in this case before, and Mr. Edge and Mr. Swift were here. Back then, E3 had Arnold Golden Gregory representing it. Mr. Pym was present, I think, virtually because E3 is his company, but he wasn't a defendant at that point. And then you, Mr. Kenner, represented Ms. Robinson.
Correct.
And you're right, it does say here preliminary injunction. Be that as it may, it related to what we're talking about. It related to the business on Edgewood that had been Chicken and Ice, and the business divorce, lack of divorce. Some people might call it a kidnapping, others call it a walking away from or abandonment. And I'm gonna hear from both sides. I'm not taking sides. I'm just mindful that there are two sides. But we had that hearing a long time ago. But what has changed is that now the Edgewood property is either already reopened or is going to reopen in 4 hours. And I'll hear from both sides on that. I've been doing my reading. But it's in play again, but now as Harold's Ice Bar, which would be a joint venture. And I don't mean that formally, it might be a partnership or something, but it is a business arrangement between Ms. Robinson and Mr. Pym, notably to the exclusion of Ms. Rutherford. And so we do have something scheduled for next week, which I think is a continuation of the preliminary injunction hearing. It's all injunctive relief, whether it's a TRO or a preliminary injunction. You guys don't have to stay standing. I'm going to give you each a turn to talk. I just want to let you know sort of where I've gotten so you don't have to backfill, or you can quickly correct me. But the reason why we couldn't wait until next week to really talk about some of the same stuff was Ms. Rutherford's perception, and by perception, I don't mean you're wrong, it's just I'm hearing two sides to it, that there was something big about to happen this weekend with the property that has always been, not always, but of late associated with Harold's Chicken and Ice, and it's going to be reborn as Harold's Ice Bar. That's potentially a trademark issue, et cetera. And we couldn't wait until next week because of the change in circumstances that would be created by, I'm going to call it the grand opening. I appreciate that maybe there was already a soft opening, but just for nomenclature, let's call this weekend the grand opening of Harold's Ice Bar. And so it was that event that precipitated Mr. Edge to say, hey, we can't wait until next week because maybe the horse is out of the barn by then. And so we need to see if there is some type of injunctive relief that ought to be put in place immediately that we would then talk more about next week at our regularly scheduled hearing. Is that sort of, I'm going to start with you, Mr. Edge. I have a bunch of questions for you, but am I sort of setting the stage, or tell me what I'm missing?
Well, a few things, Your Honor. Mr. Pym has always been a party.
Okay.
You said that he was added later on, but
It's always been Mr. Pym and E3.
E3
Okay.
too, yes, sir.
All right.
And
Who represented Mr. Pym back when we had our initial hearing?
Knox Withers, Kelsey O'Neill with the law firm.
Got it.
Voting
So they represented both Mr. Pym and his business.
Yes, sir.
My notes just said E3. I'll write Pym down there too. So
Yes, sir.
both have always been in. Originally, AGG represented them, and
Since withdrawn from the
Got it.
case. And Your Honor, also at that hearing, we learned for the first time that Mr. Pym and that Bobby Robinson had partnered and formed a corporation, Harold's Ice Bar Inc. We later filed a motion to add them as a party defendant, and you granted that motion, and then they became a part of this litigation.
okay. That I agree with. I agree with all that. To me, the addition is, no, Mr. Pym was in from the beginning.
Yes, sir. And also one final thing, Your Honor. The name of the business is Harold's Chicken and Ice Bar. And that is still the name of the business that they are trying to reopen. So after that hearing, we supplemented our preliminary injunction brief, and we basically made an argument about common law trademark infringement. And that's kind of what this case has morphed into.
It's been a lot back and forth about trademark. And I'll tell you what was particularly helpful was reading Mr. Withers and Ms. O'Neill's brief on it from way back when. I know they're not in the case anymore, but it's in the docket. And that was a good frame up. And I saw some of it resurface in Mr. Kenner's response to the TRO. And we're going to talk about that today some. But I do want you to clear up one thing for me, and then we have to take a quick pause. I'm presiding today too. That wasn't on my schedule, nor was this. But a colleague was unavailable to be here today for his presiding duties, which is why I swore in that officer. And I have another presiding thing that we're going to deal with in just. You're with DCS? Okay, well, I'm going to deal with that in just a sec. But Mr. Edge, what I could have sworn. I don't need to swear. Let me look at your fifth amended complaint. More on that in a minute. It's coming up. Slowly. Yeah, so Harold's Ice Bar, that's a party. That's just the corporate name, but not the name. If I went to,
I'm sorry, sir.
well, I'll ask my question more clearly in a minute. I just want to get the right street address. What's the street address on Edgewood? 350, 349.
Edgewood.
Okay.
Avenue.
If I went to 349 Edgewood right now, if we took a field trip, we all went down there, is there a sign up outside that says this is the name of the place? And if so, does it say Harold's Ice Bar, or does it say Harold's Chicken and Ice Bar?
Well, Your Honor, I had my client to go out to the property yesterday.
I love it, because we were going to see what Google Maps showed us.
And took a picture. The outside is the exact same as when Ms. Rutherford owned the business.
Okay.
The exact same name, same sign, same everything.
But I'm not mistaken in saying that the defendant you added was Harold's Ice Bar, because that's the corporate entity that Mr. Pym and Ms. Robinson
Are
created.
trying to manage this business. So
Okay.
the business is Harold's Chicken and Ice Bar. They use Harold's Ice Bar to own and manage the franchise.
Okay.
Yes, sir.
Got it. So Harold's Ice Bar, that name, that's not a place I could go visit and
Oh, no,
order
sir.
some chicken and get a beer.
No,
I would
sir.
be going to Harold's Chicken and Ice Bar, which was the name we've always been dealing with.
Was the name that Ms. Rutherford and Ms. Robinson created. There's
well,
articles that's out there that talk
We got it.
about
I don't know that you're going to get pushback on that notion. Even Mr. Kenner's briefs say, yes, there was that. And then someone walked away from it. Thank you for clearing that up.
Yes, sir.
Be ready for questions from me in just a moment.
Sure.
I need to look at this.
Okay.
So you are, ma'am, from DCS, you are?
Yes, I'm Officer Davis.
Officer Davis. Are you assigned to a particular judge or a unit?
So my judge is Judge Whitaker. She is out and is out. And my senior assistant, she calls and asks if I can come here to be signed by the presiding judge.
Okay, that's me. And all you're trying to do is to dismiss
Probation warrant for.
For Mr. Holmes.
Safety in the jail. And then have him just appear in court for his verification in the month.
Got it. Okay, so he knows there's an issue, Mr. Holmes, and he's going to show up, but it's going to be a self-report thing.
That's what they're requesting, yes, sir.
Okay, all right. Here we go. Thank you.
Thank you, Your Honor.
All right, Mr. Edge,
Yes, sir.
tell me when Ms. Rutherford first learned about the festivity, the grand opening, what we're calling the grand opening.
She found out about it May 12th. On May 11th, Mr. Pym and Ms. Robinson used Harold's Enterprises social media account to post a flyer inviting people out to the grand opening. That was the
Okay.
first time that it was on the internet.
It was the 11th, and your client saw it on the 12th.
On the 12th.
Okay.
I received that and almost fell on my face because I'm like, why are they opening a restaurant under a trademark that's in dispute, that's subject to our motion for preliminary injunction, subject to the hearing, days before the preliminary injunction
Right.
hearing?
No, I get you. Your argument is this is highly suspect timing. It's to try to get out and run in before there'd be an injunction, because then the status quo is, well, they're already in business. I appreciate your read on it. You're saying that Ms. Rutherford became aware on the 12th, so 3 days ago.
Yes, sir.
Okay.
Because they posted it on the 11th.
You've hopefully read what I've read, which is Mr. Kenner asserting that actually the restaurant is open now and has been for a few weeks. There was a soft opening. Do you have any reason to disagree with the statement that last weekend I could have gone to 349 Edgewood and had me some good chicken and whatever beverages they serve?
We would have had to know. That's the thing. And so.
But do you have a reason to doubt that? I'm not.
I don't, Your Honor, I don't have a reason to doubt that, but can I add some color to that? A couple of weeks ago, I had a call with Mr. Kenner, and that conversation was more so like maybe a 6.4 conference between myself, Don Swift, who's not here, he's on vacation with his family, he'll be back on Tuesday, and Mr. Kenner. And the basis of that call was because we sent discovery requests to all of the parties, right, concerning, one, when was the restaurant going to open? Communications between Bobby Robinson, Cameron Pym, things that we needed, right, before the preliminary injunction hearing. Mr. Kenner tells me, wait, we can't give you that information, right? We can't give you that information before the preliminary injunction hearing because it's harmful to my clients. That we can't give this to you. So then he ends up filing a motion to dismiss, a frivolous motion to stay. And the argument is we have this preliminary injunction hearing that's upcoming. This would be detrimental to my clients. But then after the conversation, they go behind my back, my client's back, the court's back, and tries to open up the restaurant. And he never told me.
Don't pull me into it. I haven't said no one can open a restaurant. So
Yes,
no
sir.
one's going behind it. You may feel like someone wasn't upfront with you, but I didn't issue any rules or regulations saying one side can do this or one side can't do that. So, but I appreciate you adding that color. A request, if you're going to continue to amend your complaint. We're on version 6 now.
There's 5.
Well, Fifth Amendment
Yes, sir.
would say to me there's 6 because
Right.
your first amended would be your second.
Right, yes, sir.
Get your complaint, your first amended. We're on the Fifth Amended, so that's 6. It's real hard to know what's changed. You're going to tell me in a minute because I'm going to ask, but I spent a whole lot of time looking at the Fourth Amended, which was the current one, and comparing it to the original. Like, okay, what's changed? And some of it has been responsive to things that the defense files, and I appreciate that. But it's real helpful to give a reader's guide up front. Either all you do is include the things that are new and you adopt everything else, or at least there's a paragraph that says, hey, we added count 6. Everything else is the same. Because without saying it, I don't know, I mean, count 1 still says whatever it says, but maybe you put something different in there. And I don't know what's different. And so I'd ask,
Yes, sir.
direct, that if you are going to file a 6th amended complaint, which would be the 7th complaint in the case, you include either in it or with a separate filing, here's what's changed.
Yes, sir.
It's the right way to allow everyone to reorient.
May I respond to that, Your Honor?
Yes.
All right, so we filed the 6th amendment complaint because
It's the Fifth Amendment complaint.
Fifth Amendment
Just
complaint.
the 6th one.
6th one.
Yeah.
Yes, sir. Because we added a verification from Ms. Taryn Rutherford because we forgot to add one to
Okay,
the.
but that's it. The only thing is,
That's the only thing.
the difference between Fifth Amended and Fourth Amended is a verification.
Yes, sir.
So if I spent some time digesting Fourth, I now have just digested a verification as
Same
well.
thing.
Got it.
Right.
Thank
In
you.
the 4th, it was in response to Robert Kenner's motion to dismiss, right?
That was very clear.
He basically said that we didn't have a torturous interference claim against Mr. Pym between Harold's Chicken Corporate.
I read the motion to dismiss, and some of them were, you don't name all the defendants in some claims, and but I'm going to talk about the motion to dismiss before we wrap up today as well.
Yes, sir.
Okay, so the change from Fourth Amended to Fifth Amended is a verification.
Yes, sir.
All right.
Then, and the ones before then came, we haven't gone through discovery, right?
We're going to talk about discovery also.
Yes, sir. So we find out a lot of information at the preliminary injunction hearing. And so that's how we ended up morphing our complaint to add several claims, right? Like the common law trademark infringement claim and some other claims. And so that's essentially what has taken place, right? Yes, sir.
Okay.
Because we were finding out information through the early phase of the lawsuit. And so we had to shape our complaint to the facts that we learned. So that's how we ended up getting to this point.
Got it.
Yes, sir.
Okay. Before I ask you to share with me why you think I should grant the TRO, Mr. Kenner, is there anything procedurally you want to share? You will be given a full chance to say, here's why the TRO isn't appropriate at this time. So this isn't your time to do that. But I was just trying to get oriented. It's been a while since I saw everyone. I want to make sure I'm up to speed. And as I groused a little bit, Fifth Amendment complaint, I don't even know which version we're on now, but I get it. It's basically Fourth. And with that, I am current.
Yes, no, Your Honor, I think you have laid out the history of the case. The last time we were here for preliminary injunction. I think I was on cross-examination of the plaintiff at the time, and then we had to stop. So that's what.
Okay, got it. All right. So, Mr. Edge, I'm ready to hear from you. I'll tell you, you can cover anything you want, but here are my areas of concern about providing injunctive relief at this point in time. One is the viability of the trademark claim, and I should tighten that up. The viability of Ms. Rutherford's ability to bring a trademark claim if in fact it's Harold's Enterprises trademark claim, which I think kind of structurally it is. So you're going to talk about that.
Yes, sir, I will.
And then even more so, the irreparable harm.
Yes, sir.
Because if I agreed with everything you put forth in your motion and in the Fifth Amended complaint, it sure seems like in the end, Ms. Robinson and Mr. Pym could stroke a check and Ms. Rutherford would get her share of whatever had happened. But you're shaking your head,
Oh, sir.
and so that's why we're here. So you can educate me
Yes, sir.
as to why the sky falls if Harold's Chicken and Ice Bar continues to operate under that name, not Harold's Ice Bar, at 349 Edgewood.
Well, I'll start off by saying that, and I think you read it right, Your Honor. I do believe that the defendant accelerated the opening process before the hearing because of bad faith, right? There's all the conversations that I had with Robert Kenner. He never once told me that his clients were preparing to open. Would have appreciated a heads up about them trying to open the restaurant, especially days before the preliminary injunction hearing. And it shows that this was intentional infringement, Your Honor. And even the defendants admitted in their response motion that make sure I say this right, that the status quo has been altered, right? They're saying, well, we have this TRO that we have this TRO that's pending, that we're open, that we have balloons, we have ribbons, that the status quo has altered. But Your Honor, they're wrong. And here's the reason why they're wrong is because Georgia law says so. In the case of Inkaholics Luxury Tattoos, Georgia, LLC versus Pardon, which is 324 Georgia App 769, 2013, the parties were fighting over a trade name. While in litigation, the defendants argued that the use of the alleged infringed name altered the status quo. The Court of Appeals rejected this argument. The court held that in a trademark infringement case, the status quo to be preserved by an interlocutory injunction is not the situation of contested rights, but that the last peaceable non-contested status of the parties. So what does this mean? The court does not treat the defendant's ongoing use of the allegedly infringing trademark during the lawsuit as the normal situation that deserves protection. Instead, the court looks back to what was the situation before the junior user began using the mark.
So two questions about the applicability of that case. One, what does junior user mean? And how would that apply here? Because I think we've got 50-50. So there's not a junior, there's a equal, which I think would make your client's claim stronger because there's not wasn't a lesser partner. But two, you're going to need to weave into all of your responses in the trademark area. Didn't she abandon it?
Okay.
And your response to that, because I heard the testimony, I've read the affidavits, and I think that I'm not sure how you demonstrate a strong likelihood of success on the merits. That there was a point at which Ms. Rutherford said, "Forget it. We've driven this into a ditch. It's not working. I'm not interested in going further. I'm out of here."
Yes, sir. Well, that's not what happened. All right. So the first question was, I'm sorry, what was the first question?
So the case you were citing,
Yes,
Inkaholics, talked about the status quo isn't the junior person using it, and Ms. Robinson is not a junior user. She would be a co-equal. So it wouldn't be the case that Ms. Rutherford was a 70% owner of the trademark, and Ms. Robinson was 30. They were, at the time, if there was no abandonment, 50-50.
Your Honor.
Or they were neither because, of course, it's Harold's Enterprise.
Your Honor, well, it's not just Bobby Robinson. It's Cameron Pym. Cameron Pym wasn't a party to the agreement with Harold's Chicken Shack, right? He didn't have an agreement with Christian Pierce. Taryn Rutherford, Bobby Robinson did. He didn't. That's the problem. They created a new company to use this trademark that she owns 50% of.
Why do you use the past tense?
She owns it.
Okay.
Yeah, she hasn't relinquished it. She hasn't abandoned it. What happened is, yes, she got frustrated and she said, "Hey man, like this is just too much for me." But then she told them, "Well, no, it's not." She rescinded whatever offer she made. She rescinded it, and she has every right to do so because she saw that there was conspiracy, there was fraud, and she rescinded that offer. So she never abandoned it. And also, Your Honor, the interesting thing about this, and something that I read in defendant's motion, was that they're saying that this right belonged to Harold's enterprise, right? But a fact that Mr. Kenner failed to mention is that Bobby Robinson terminated the company. She dissolved the company. So what happens when a company is dissolved? The assets are distributed to the shareholders equally. So what does that mean? That means that Bobby Robinson owns a half of the trademark. Taryn Rutherford owns a half of the trademark. So Bobby Robinson cannot open a restaurant under the name Harold's Chicken and Ice Bar at the 349 Edgewood Avenue without the consent of Taryn Rutherford. And Taryn Rutherford cannot open Harold's Chicken and Ice Bar at 349 Edgewood Avenue without the consent of Bobby Robinson. That was the agreement. And so the argument that Mr. Kenner is making is a fatal argument. She owns that trademark. She has every right to that trademark.
Well, she co-owns it.
You're right, Your Honor. She co-owns.
So she has some rights to it, but
Yes,
she
sir.
doesn't have exclusive rights, which is what your argument is about Ms. Robinson, that Ms. Robinson shouldn't be able to do something, I guess, without Ms. Rutherford's sign off.
Can't do the same thing, Your Honor. It's like they can't have it both ways here. Like she can't do it, Ms. Robinson can't do it. And Your Honor, as we told Mr. Kenner, they can open a restaurant. It just can't be named Harold's Chicken and Ice Bar because she owns half interest in that trademark. Now you ask me, well, Mr. Edge, I'm having trouble understanding the irreparable harm piece.
Right, before you shift gears on that,
Sir.
Ms. Broussard, how are you?
Good, how are you?
I'm well. I need your driver's license because that's how I see. Yep, look at that. You live in Atlanta. So if you give it to Sarge, she'll get it to me. Then I can sign this. All right. So, Mr. Edge, you were about to get to the irreparable harm part.
Yeah. Also, I forgot. Well, client pointed something out, Your Honor.
Thank you. You guys confer for a second. I can check this out. What are you going to be studying at Morehouse?
Listen,
Like to get an MD? Congratulations. It's a long road, but you'll make it. You will make it. All right. Good. Okay. All right. Irreparable harm.
Before that, Your Honor, there are some facts that I want to weave in that
Okay.
I think that we didn't cover. And I'm sure you remember this. Remember, they told Ms. Rutherford that they were closing the business, right? So at that point, she threw her hands up and said, listen, let me try to sell, right? But then she discovered that there was conspiracy and there was fraud. And she was like, no, I'm not about to give you this company. I'm not going to do that. And then also, another thing is that we have this affidavit from Ms. Kristen Diane Pierce, who has since passed away, who said that she never authorized, she never agreed to them opening up this restaurant under this name. And I know that's not really our point to make, but I just want to add that color.
But which name? I thought your whole point was
Chicken and Ice Bar at the 349, because she said that.
But what, if we go back 4 years and Ms. Rutherford and Ms. Robinson are still talking and they're running a business at 349 Edgewood, was it not called Harold's Chicken and Ice Bar?
Yes, sir. It was called Harold's Chicken and Ice Bar.
Right. It was called this. So but you just told me that the franchisor never, in her affidavit, said, I never let them open a restaurant with this name.
Bobby Robinson and Cameron Pym. She never agreed to them opening up this restaurant at this location because, Your Honor, this is the flagship restaurant. I mean, this is the known restaurant on Edgewood Avenue. And everyone knows that.
Well, it had been till it closed.
Till it closed.
And it was closed. And now it's reopening under the same name.
Under the same name, same menu, same drinks, same hookah, same everything, same sign on the door.
Yep.
Right. And so when we talk about irreparable harm, the defendants have accelerated and compounded consumer confusion. Like we just said, same sign on the door, same menu, same service model, this lounge service model, and the same advertising methods. As I mentioned earlier, Your Honor, they're still using the Instagram account that Taryn Rutherford helped build. They're advertising the reopening of Harold's Chicken and Ice Bar to the customers that Taryn Rutherford helped generate. These are people that know Taryn Rutherford. These are people that know Bobby Robinson. These are people that read the Rolling Out magazine, where Bobby Robinson is saying that Taryn Rutherford and I created this name, that we were college friends and we created this service model. This is something new. We are on Edgewood. This is the place where you should be, right? And so the defendants have caused immediate injury to Ms. Rutherford's reputation, her goodwill, the brand control that cannot be easily quantified. What if there's bad food quality? What if there's bad service? What if the restaurant isn't clean? What if the pricing is too high? What if the customer experience is not good? That's associated with Ms. Rutherford's brand. I tell you this, Judge, this weekend, I'll be celebrating my 10-year college reunion. I graduated from Morehouse in 2016. This is my 10-year anniversary. And when I was a student at Morehouse, if you were to ask where I would be on a Friday night, around 7 o'clock, I would be at Harold's Chicken and Ice Bar on Edgewood. And I would be there with my friends, right? So let's say...
You're going to go this weekend?
I won't, because I have 2 hearings next week. I will not, unfortunately. But what I will say is, think about this weekend, Your Honor. It's been 10 years since I've been to Harold's Chicken and Ice Bar. And I walk in, same sign on the door, same menu, same waitresses, same bartenders, same tables, same fryers. We talked about fryers last time, but everything is the same. But when I get there, the food doesn't taste the same. The drinks doesn't taste the same. Nothing is the same. And I say to myself, what in the world has happened here? This is not the same place that I went to, that I used to go to 10 years ago. So what would I do? I would go to Google review and I would put on Google review, I am highly disappointed in Taryn Rutherford and Bobby Robinson. What happened to Harold's Chicken and Ice Bar? This is not the place that I used to go to. This is not the place that became my home. This is something different, right? So then millions of people would see this review and they will associate that to Taryn Rutherford.
So how is that different than if Mr. Pym had bought Ms. Rutherford out, and they clearly had a discussion about that, and they were close to a buyout. So Ms. Rutherford, there's actually a paper trail that she's out. You bought me out. I'm done. I don't have anything to do with this building, this business. You have my share of Harold's enterprise. So it's now Pym and Robinson.
Right.
And fast forward to this weekend, and you don't have 2 hearings next week. And so for your 10th college reunion, you and the guys go there, and it's a dud. But you had no idea, because who follows that Ms. Rutherford sold her shares to Pym. And you go online and you say, I am highly disappointed in Taryn Rutherford. Well, you're misplaced in your disappointment. Ms. Rutherford might feel bad when she reads it, but what is her cause of action? And really, what's the harm to her? But that same situation could come to pass.
Well, I'll tell you this, Your Honor. The defendants robbed that opportunity to find a solution for Miss Rutherford. Because guess what? Had they not stole the business from her and tried to steal the trademark from her, they could have entered into an agreement, right? And what could have happened? They could have played damage control. They could have gone on social media with all 3 of them. Hey guys, I'm no longer with this company. Bobby Robinson and Cameron Pym are together. They are the new owners. They could have advertised this everywhere. They could have worked together, but they didn't want to do that. What did they want to do? They wanted to steal from Miss Rutherford. And so you're talking about the harm. Money can't cure this harm. Money can't cure harm to her reputation. Money can't cure harm to her goodwill. Money can't cure harm to her reputation. Like, money can't cure any of that. Every operational day increases customer confusion, advertising penetration. And that's what they're doing.
So tell me what the customer confusion is.
The customer confusion is, as I said in my hypothetical, I walk in the store, right? I think Taryn Rutherford is still an owner of this location.
Right.
Right?
But what does that have to do with, I mean, if you end up having a great meal and you post online, Taryn Rutherford is the bomb. She continues to run a great restaurant. But she's getting free positive publicity. Should she be paying Pym and Robinson for that? Dang, I didn't do anything. And you guys invested $750,000 to spiff this place up. And people are saying, Rutherford, she's great.
But Your Honor, it's the threat of harm. That's what we have to look at. We're not looking at the positive. We're looking at the threat of harm. And that's a part of
why do I assume that it's going to, you're asking me to assume that it's a bad outcome. The threat of irreparable harm generally is they're going to cut that tree down. Well, once the tree's cut down, you can't put the tree back up. That is, you cannot repair a cut down tree. And if they're allowed to go forward, we know the consequences. Tree is removed. Here, you are saying, what if there's a bad experience? What if there's a great experience? What if it's better? And people say HCIB 2.0, even better. I'm going to reach out to Ms. Rutherford and see if she'll help me start a business. And she gets spin-off business for something she didn't even do.
Well, Your Honor, with as far as the customers, Ms. Rutherford will lose control of her identity in the market, right? So she owns the trademark. And when it comes down to common law trademark, the law is treated a little bit, in my opinion, is a little bit more sensitive, right? Because it's, like you said, the analogy, the horses are out the barn, right? And so we're trying to do all that we can to prevent the horses from going out of the barn. And that's why we're seeking this temporary restraining order, is because we are trying to preserve the status quo so that when we come to Tuesday, there can be a final decision that's made that whether this restaurant is going to shut down for the duration of the trial or they're going to open. And whatever the court so chooses, we have to accept that. But we want the opportunity to be able to have our day in court. And the defendants tried to usurp that, Your Honor. And think about it. They strategically did it. They did it days before the hearing. As I said earlier, that is the epitome of bad faith. You do it days before the hearing so that they could come to court and say, Your Honor, we're open, We have lines down the road. We're doing great. We're on the radio. We're everywhere. They wanted the opportunity to do that, to cut our chances from even being able to present our case to you. And this was strategically done. And the law says that this is improper, that they cannot alter the status quo by infringing on a trademark that Ms. Rutherford co-owns. And for those reasons, we ask that you find in our favor, that you see that the balance of equities fall in our favor. Any harm that Bobby Robinson, that Cameron Pym, that Harold's Ice Bar, that they suffered was self-inflicted because they always knew that we had this hearing. They chose to open up before the preliminary injunction hearing. They could have waited for May 20th to open. It's only a few days. They could have, but this was strategic. And they wanted to make our case tougher. And we ask that you see the bad faith that the defendants have done, that you grant our temporary restraining order, and that you allow us to come back on Tuesday for the preliminary injunction.
What, point me to, it may have been something from our last hearing, it may be somewhere in the pleadings. Where do you anchor your claim that Ms. Robinson dissolved Harold's enterprise?
Mr. Kenner, he admitted it.
So tell me where that is, and how would Ms. Robinson have the ability to dissolve
She didn't. She unilaterally did it. We didn't know anything about it. Your Honor, we sent her
So is it dissolved? If she doesn't have the ability to do it.
She did it.
Well, but does that mean it's dissolved just because someone says they did something?
We have a claim for declaratory judgment to have the court to say that this company is not dissolved. But we have, and I hope.
So your view is that it's not dissolved, that an effort was made to dissolve it, but it was basically ineffectual because a half owner can't dissolve a corporation.
Your Honor, according to the Secretary of State, it's dissolved. Certificate of certification. It's a public record right here. And remember, at the hearing, you were surprised. Because you were surprised that Mr. Kenner, he blatantly said it. Oh yeah, the company is dissolved. She dissolved it. She dissolved it. And Your Honor, we also attached a shareholder inspection request. We requested all of this. She never gave us anything. We sent discovery. They never gave us discovery. We've just been in the dark this whole time. So that's why we've had to amend our complaint so many times, because they're not even working with us. They've been operating in bad faith since the beginning. So when she dissolved this company, the assets flowed to Ms. Rutherford and flowed to Ms. Robinson.
So a termination is the same as dissolving. This is a certificate of termination.
Your Honor, I see termination as being dissolved.
Okay, I'm not.
And I have an email that's a part of the record where I'm emailing Ms. Robinson before she retained Mr. Kenner, where I'm trying to get books and records, and she say, oh, the company is over. The company is dissolved. There's nothing we can do. Go to the accountant. We sent the accountant a third-party request. We never got anything from him, Mr. Stephen Betts.
It was 1 year ago yesterday.
Yes, sir. So we've been working diligently. Everything that the court has required us to do, we've done it. And what do the defendants do? They try to pull the rug from under us.
Okay. Thank you.
Thank you, Your Honor.
This exhibit has a number. That numbering would have been from the hearing before.
Yes, sir. I didn't get a chance to use it.
We didn't get as far as
Yes, sir.
everyone
Yes, sir.
had hoped. Okay, Mr. Kenner, your thoughts. And why don't you start with, since we're on the topic, the termination or dissolution of Harold's enterprise, which your client has advocated for, as in this is a fact, it happened. And if so, that does shift a little bit of the way I had been thinking about it, and something you had wisely positioned yourself behind, which is this is Harold's Enterprise's claim. I don't think Harold's Enterprise has any claims to make, given, I'm going to just call it Exhibit 18, but your client, I should be clear, Ms. Robinson, her termination of that corporate entity, wouldn't that result then in the assets of the corporation flowing to the members? So then we really do have a trademark co-holder in the form of Ms. Rutherford saying, I feel like my trademark is being misused. It's certainly not being used with my permission.
No, Your Honor, it does not. Let me tell you why. The parties had a conversation back in 2024 when
And when you say parties, because we've got Mr. Pym in the mix too, who are we talking about?
we're talking about Ms. Robinson and Ms. Rutherford, right? The relationship, if the court remembers, there was some testimony, and I think I got it out through cross-examination, that the relationship between Ms. Rutherford and Ms. Robinson became very sour. And it went south very quickly after an allegation that Ms. Rutherford stole from the business. At that point, Your Honor, these two individuals never had any verbal communication after that. They had text messages between the two. During that time, the professional relationship broke down. And that's when they talked about resolving the case. I mean, not resolving the business. They talked about getting rid of the business because at that point they weren't making any money. There was an allegation that they weren't making any money. I think Ms. Rutherford tried to say, "Oh, we were still making money." But at some point, and I think it's in the record, that Mr. Pym approached Ms. Rutherford to buy her share, her half. They never got to that point to where they executed that deal because there was some issues with the bank and all, and I think the parties their communications broke down. Ms. Rutherford made it very, very clear. We have it in text messages. I think she admitted it in the text messages when she was on the stand, that she wanted no parts of the business. She wanted to be out, and she understood that the business was going to close. She also understood that at some point the business was going to reopen under new management and ownership without her. The new manager and owner will be Mr. Pym as well as Ms. Robinson. She didn't pay any more in terms of the bills for the business. She didn't pay the employees. There was an issue where she had taken money from the account that almost drained the account. That evidence came into play at the last hearing as well. So you want to? I didn't interview you. I mean,
yeah, you need to.
I'm sorry.
Yeah.
I mean, I could put
You're welcome to write notes to your client, but no commentary on what's being said.
So Miss Rutherford acquiesced in the business being basically dissolved. Now,
Remind me what your recollection is of so Mr. Pym was the E32 was the landlord.
Landlord, correct.
Okay, and so Mr. Pym, as the member of E32, he's the landlord.
Correct.
That's his connection to this.
Correct.
And was there not some commitment? I don't know if it was in a lease or what it was, this build out where Harold's Enterprise had committed to spending money,
Correct.
improving 439.
Not Harold's Enterprise. It was between
349. It wasn't the business that.
Well, let me just say this. Prior to the company dissolving and the partners basically their relationship souring, according to the lease, and I think it was Amendment 3, Ms. Robinson and Ms. Rutherford were supposed to do a build out.
Okay, well, whether you stick it to Harold's Enterprise or the two of them, there was a commitment on the part of.
It was Harold's Enterprise.
Okay, to improve the premises.
Correct.
Not only are we paying rent, but we're also committing to, I'm gonna make it up, add an HVAC unit, but they were gonna do something to
Build out. They were going to
build it
build out. And it was going to cost about over $200,000 to do.
And they either were behind on it or they said, like, how can we do this? We're losing money as an enterprise.
Correct.
And so we don't have 200,000 to do this improvement.
Correct. So they never did it. And so what happened was Mr. Pym went through his resources, and what he did was able to get a loan from his financial resources of, I believe it was about $500,000. It was a lot of money. And he was going to give Harold's Enterprise about $250,000 or so for the build out. But the Harold's Enterprise, Bobby, as well as Ms. Rutherford, they never completed the deal. So they were in breach. At that point, Your Honor, Ms. Rutherford decided that she didn't want to be a part of this deal. She didn't want to be a part of Hal's Enterprise, or not Enterprise, but Hal's Chicken and Ice Bar. She had her own Hal's Chicken and Ice Bar, as well as my client, Ms. Robinson. She had, I think at the time, she had three. I think she still has three. I think Ms. Rutherford has at least two. Incidentally, Your Honor, there's a Hal's Chicken and Ice Bar in Illinois right now that's operating. And so at the point where Ms. Robinson decided that she was going to basically send something into the Secretary of State saying this business is over, it's terminated, because she did not want people coming back trying to sue her, trying to sue the business or whatever. She said it was over. And it was by her.
What, I'm not remembering the name of the franchisor. Ms. Pierce?
Yes.
Ms. Pierce.
Who's deceased.
She's deceased. But do we know if the agreement between her entity, and maybe it was just a personal agreement, but regardless, between Ms. Pierce and she's Chicago?
Chicago.
So Chicago and Atlanta was, hey, Ms. Rutherford and Ms. Robinson, I bless you using my name, not Pierce, but Harold's Chicken and Ice Bar.
Correct.
And you do what you want down there. Or was it, because the way Mr. Edge was describing it, that Ms. Pierce had this vision, changing his words a little bit, but that 349 Edgewood in particular was that, yep, if you guys are going to open something, it's 349 Edgewood. I am authorizing you to have Harold's Chicken and Ice Bar at 349 Edgewood. That seems peculiar to me that she would say it has to be at this real estate, especially given what you just said, which is, hey, Ms. Rutherford has other Harold's Chicken and Ice Bar, just like Ms. Robinson does, which says to me, they are both able to operate Harold's Chicken and Ice Bar. And it may be for Morehouse grads and alums and whatnot, the 349 Edgewood is a magical space, but they both seem to have the ability, Rutherford and Robinson, to open up others. And so I mean, this is going to be Mr. Edge on rebuttal, but I'm not understanding what the trademark dilution or confusion is. Let me ask it this way. Is it your understanding from the franchising agreement that Ms. Robinson, your client, if she wanted to open up another Harold's Chicken and Ice Bar, she could, because she's basically been given the ability to use that name to operate a business like, it's not, it'd be a car dealership, but a restaurant where there's chicken and there's a hookah, et cetera. And she could open one in Fairburn if she wanted to, or she could open one in Alpharetta. Or was it specifically that Ms. Pierce said, those are your spots. You cannot have any more. You have to come back to me. I have to approve, like McDonald's, we have to approve the real estate. We don't want you putting one on a back road. It's got to be a good place with high traffic.
First of all, Your Honor, it was never a written agreement.
Okay.
Never a written.
Of course not. Right.
So there was never anything that was writing that said that the parties, that Ms. Rutherford and Ms. Robinson had to open up a specific location. They could have opened it up in Buckhead. They could have opened it up in Riverdale. They could have opened up anywhere. The only thing that they were allowed to do was use the name. And the owner never said that either one of them or that both had to use the name together. That was never said.
Which is why Ms. Robinson has some Heralds that are just hers.
Correct.
And you're saying Ms. Rutherford, I'm remembering this testimony that
she has one in Panola Road. I think she had one in College Park.
Riverdale.
Also Riverdale, and also, Your Honor, there was another Harold's Chicken Shack that was in the same location. Actually, I believe it was in the same, right next to her business, which is Harold's Ice Bar. And so the owner never said, okay, you have to have it at a particular location. She just said, just pay me. If you want to use it, just pay me.
Okay. Was the Edgewood address the only one that was Ms. Robinson and Ms. Rutherford together?
Correct. That was the only one.
And Harold's Enterprise was really the owner and operator of the Edgewood one. That's how they were doing it jointly, is that they formed Harold's Enterprise.
Correct.
So your client may have an LLC for her other Harolds. She may not, but more importantly, they aren't a Rutherford Robinson partnership that has since fractured.
That is correct.
Okay. So this is the one location where I'm gonna call it a joint venture between the two R's. Okay.
Correct. And another thing I want to point out, Your Honor, I don't know if the court remembers this, but there was no operating agreement between Ms. Rutherford and Ms. Robinson as to who would own the trademark, if they own the trademark. As a matter of fact, I believe at some point they tried to trademark it, but they couldn't trademark it. So I disagree with this whole argument that there's some type of ownership in this trademark.
Well, why? Tell me why I don't want to get hung up on common law trademark, because I know we don't have a trademark that we'd go to the trademark office for. But there's certainly goodwill that's associated with this. No one has come in here saying, no, man, let me tell you, the Panola Road, that's the Herald's. This Edgewood one is fine. I go there if Panola's closed, or if I get a flat tire and I couldn't make it back to Panola Road. The vibe seems to be that the Edgewood one, that's sort of the mothership of Atlanta area Herald's.
Well, Your Honor, if it was a mothership and it had such a great reputation at some point, then it wouldn't have closed.
So that's a fair point, but what I haven't seen is evidence, which people could have gathered, where, I mean, because we've got an affidavit saying, let me tell you, you've already criticized it, but the affidavit that a little dated about the significance of the Edgewood Heralds. And I didn't hear during the testimony or from argument on either side that the other Heralds they were sort of, I'm gonna call it a first among equals, that the Edgewood Heralds, if someone was coming in from out of town, like, man, I want to go to that Herald's place I've heard about, they probably weren't talking about Riverdale. It's not a knock on that one, but they were probably talking about the Edgewood one.
Well, we don't know, because
I definitely don't know.
well, let me just say this, and I will give Ms. Rutherford her kudos. She has a very beautiful establishment out on Panola Road. It is very, very popular. I mean, it is gorgeous. And so she is doing very well on Panola Road. Now, someone may come to Atlanta and said, I want to go to Hal's Chicken and Ice Bar, and hey, you need to go to the one in Panola Road because it's up to date. It's really nice in there. The food is great. I haven't heard any complaints about the food, and so I would not commit to someone saying, "Oh, I've got to go to the one in Edgewood because that's the flagship or the mothership."
So your point is when Harold's enterprise dissolved, was terminated, there wasn't a trademark that dropped into anyone's lap because both of the partners had the ability to use this name.
Correct. And neither one of them, and I would argue, Your Honor, that neither one of them exclusively owned it. I don't believe that they own, we were talking about earlier, well, do they own 50% of it? I would argue that the owner, the original owner of Hal's Chicken Shack or whatever, owns that name as well. It's not been trademarked. Nobody's filed for it. So, and anybody can use that name. As I said before, someone is using that name right now in Illinois. And I think Ms. Rutherford knows that as well. The other thing, Your Honor, is, again, Hal's, if anyone can make the argument of ownership, it would be the company. Everything that the plaintiff is saying in her now fourth or fifth amended complaint is talking about Hal's Enterprise. Hal's Enterprise owned this. Hal's Enterprise started this. It's not Ms. Rutherford. It is not Ms. Robinson. I would argue that neither one of them has any type of interest or ownership in it. The other thing, Your Honor, is counsel talked about being surprised.
He did.
And it's shocking and it's bad faith and we went out and scurried it and opened this thing. Well, first of all, they have known since the location first closed down in December of 2024 that Mr. Pym and Ms. Robinson were going to reopen, and that they had spent so much money, time, and effort to try to get this thing open. They knew that. So that what they did was they sat around and said, "Oh, you guys can pump all this money into it to rehab it, but all of a sudden now, once it's open, there's a problem." Counsel talked about the fact that he didn't know that it was open. Well, it's all over the internet that it opened two or 3 weeks ago. That's all over the internet. And I'm pretty sure Ms. Rutherford, because she has people spying, she has people, looking to see what's going on. She knew that it was open about 2 or 3 weeks ago as well. And so it was not something that we planned this. They went through the process of getting all of the permits, which took a long time. And so this was the weekend that after they received the permits, 3 or 4 weeks ago or so, they decided that they were going to open and do a grand opening. As a matter of fact, today there was a ribbon cutting with the city. And so Mr. Pym and Ms. Robinson.
Like Mayor Dickens was there?
Well, I don't believe he was there, but his office, his office was there.
I mean, now you're going to have a hard time getting me to believe that the other heralds are as important as this one if the mayor was there.
No, the mayor wasn't there. I don't know if Ms. Rutherford had a ribbon cutting when she opened her establishment in Panola Road. But the point is, Your Honor, that the defendants have spent a lot of money and effort and time trying to get this thing open. And the court hit it on the net. The court never said you can't open. The court never entered an order saying you don't open until we deal with this whole preliminary injunction. One thing that the court said during the last hearing, and that I agree with wholeheartedly, is that the remedy is damages. So
Well, I agreed with you at first, but Mr. Edge raised the interesting theory of what's the dollar amount you put on the reputational harm. Let's say, I hope things go well for the business at 349. If it's going to keep operating, I hope it goes well. Because frankly, the rising tide lifts all boats. If it's a smash success, someone's going to say, Harold's, whoa, I'm going to Panola Road. And they'll go to the wrong one. They'll have a great time because you said that's amazing. So that's great. But if this Harold's is a bomb, then and it's associated in people's minds, half with your client, meaning Ms. Robinson, but also with Ms. Rutherford. I hadn't thought that through. I don't know how you hang a dollar amount on that.
Well, let me say this, Your Honor. These two individuals, Ms. Robinson and Ms. Rutherford, are on a reality show.
The two of them.
The two of them. They're on a reality show called, I think it's called The Flavor, right?
They are together on it now?
There's a reality show of, I believe, 5 or 6 Black women, owners of restaurants. And
that must be spicy.
What is very spicy. And what was demonstrated on that show was Ms. Robinson's as well as Ms. Rutherford's opinion of each other, as well as the fact that Ms. Rutherford has indicated, even on the show, that she has nothing to do with the Edgewood location. So she has been telling other folks that I have nothing to do with the Edgewood location. That's all on Robinson. So I don't see where there could be any confusion at this point.
Well,
it's a very popular
show. For
me,
since I don't watch that show, I might be confused, but I'm probably not the target audience for Harold.
Well, I think most people understand, especially when Ms. Robinson got on the internet, Instagram, and basically talked about how Ms. Rutherford stole liquor and was stealing from the company, and that she was never dealing with her again. I think people understand now that
there was a breakup.
That there's a breakup, that they're no longer. The employees know it. People in the community know that they're no longer together. And so I don't believe that there will be some type of harm to her reputation, because people, I believe, they understand that they're no longer in partnership. And then also, that's a big assumption that Mr. Edge is making. That, he went into, the chicken, the food is the same.
No, I understood. I pressed him on that, and he responded. You are also making an assumption that people know that Ms. Rutherford is in no way associated with the Edgewood address. I mean, right now we have to deal in assumptions because we haven't reached the point where there is harm that, it is irreparable, should have done something, or it is reparable, meaning damages would make someone whole. And that's what I need to work through. So,
Your Honor, this is the thing. If it was such an immediate harm or such an emergency, then I believe Mr. Edge and his client should have last year, when we had the hearing, asked the court for at least a temporary order to prevent Mr. Pym and Ms. Robinson from continuing to rehab the place. they knew that it was being rehabbed, and they understood at some point that it was going to be open. They may not have known that it was going to be open this weekend, but if it was so harmful and it's such an emergency, then why didn't they ask the court for an order back then? So what they're trying to do now is say, oh, let's stop everything from happening this weekend, which absolutely makes no sense. And let's have a hearing on Tuesday, because they will still make the assumption that the court is going to rule in their favor. Let's assume after the hearing and after listening to our argument by counsel and testimony that the court decides, well, I'm not going to grant it at this juncture. I don't find that it's irreparable harm. I don't find that you meet the statute. And so the court would have just closed down this business for this weekend. You have employees that still need to be paid. You have radio ads. You have vendors need to be paid. You have all these things going on this weekend, and the court says, okay, well, all right, I find in favor of the defendants. I'm not going to close you guys down. Carry on. Well, that's irreparable harm at that point to the business.
But isn't it a pretty big gamble that Mr. Pym and Ms. Robinson are making opening now on the eve of this hearing? If the hearing doesn't go well for them, they will have spent all those things you just described, likely not to recoup it just through the business this weekend, but they think, great, big liftoff, and in the coming months, we'll make back all the money we spent on this grand opening when on May 19th or whatever day our hearing is, it could be screech. Nope, there will be no Harold's Chicken and Ice Bar at 349 Edgewood. You can open up a Burger King, but not Harold's.
Well, let me say this, Your Honor. First of all, we just received, I believe we received notice maybe about a week and a half ago about this hearing, the 19th. These individuals had already set in place to have an opening this weekend before we even got notice.
Of the hearing for next week.
Exactly.
Okay.
You understand what I'm saying? So they had already set in motion, because they have to go radio, they have to do all these things.
They didn't wake up yesterday and say, let's do this.
You don't just call the mayor's office and say, hey, can we do a ribbon cutting?
Well, that's why he didn't show up.
Perhaps.
Okay.
So the point is, or because, Hal's Chicken on Edgewood is not that important for him. But the point is, Your Honor, is that this is not something that was done, behind closed doors. They had already prepared for this weekend. My argument is, Your Honor, is I still believe that the court should deny their motion even on Tuesday. I honestly believe that we really don't need to go forward on Tuesday, because I think the court has enough information right now to make a decision on whether the injunction should be granted or not. I think based on the last testimony of Ms. Rutherford, I think the argument that was made during the last hearing, I think is enough that the court can make an opinion about whether one should be granted. And I also believe, Your Honor, that if the jury buys their argument, they can award damages. I think it would be to her benefit if the restaurant stays open, remains open, because if they're making all this money, now she can say, hey, you guys, if the jury believes her and find in her favor, now she can collect from a business that's doing well, is profitable. And so, Your Honor, I would argue that at this juncture, at least, that the court not grant this emergency motion and allow the company to continue to stay open through, at least throughout the weekend. I want to touch on just briefly on the fifth amended complaint, because I am in the process of filing a motion to dismiss. Well, I was in the process of filing a motion to dismiss the fourth.
You did.
Did I? Okay. All right. Maybe I did. Okay. I've been trying to respond to so many.
Well, I guess you filed one to the third.
It was
and that's
third.
what the fourth responded to.
Exactly.
There've been so many iterations of things. You sought to dismiss the third amended complaint, and then I read Mr. Edge's response, and then also saw, but you know what? We're going to amend the complaint anyway, just so there's not a debate about some of these things. Okay.
So I have prepared already. I just hadn't signed it, but I prepared a motion to dismiss the fourth, and then I learned that he filed a fifth amended complaint.
But we know the difference is just there's a verification.
And so what I'm going to be asking, I'm just giving the court heads up, I'm going to be asking the court to enter an order to limit at least order the plaintiff to file, if it's going to file another amended complaint, then file that and that be it. And then ask for leave if the plaintiff feels as though they need to file another amended complaint. Because what I'm doing is we're expending time and money chasing these complaints. So it seems to me, once the plaintiff realizes that, oh, I need to tweak it a little bit because of this argument, then they change it. So I'm going to be asking the court to enter an order saying, listen, this is your last, but if you need to do it again, then you can ask for leave, and then at that point, the court can either issue an order allowing it or not. And so, Your Honor, based on the argument and based on the fact that I don't believe that this rises to an emergency in the sense that for TRO, I'm asking the court to deny.
Before you sit down, and I hear from Mr. Edge again, you said you've largely drafted your motion to dismiss fourth, which is the fifth as well. It would apply to both. What do you add to that because I read your brief to dismiss the third, and I'm curious to know what would be new and different in it.
It's essentially the same, Your Honor, but I think there was one other argument, and I can't recall exactly what I made, but it's very similar.
Okay.
Very similar. So, and I would argue, Your Honor, if the court wants to, since there's only a tweak, since there was a tweak in terms of the not changing the facts or anything like that or allegations in the complaint, if the court wants to rule on my motion to dismiss the third, then I'm fine with that as well.
Okay. I'll let you know.
All right. Thank you, Your Honor.
You're welcome. Mr. Edge, before I hear from you, are you Custodian Smith? All right. Is that what they call you, Custodian? All right. And you're with Union City? Okay. Do you swear or affirm that the contents of your two affidavits seeking an order to destroy or dispose of evidence in the custody of the Union City Police Department are true and correct to the best of your belief and knowledge? Okay, great. Are you the one who actually disposes of it, or you hire someone to do it, or?
No, I'm actually going to dispose of it.
Does that mean you just put it, like some of this stuff you can't just put in a dumpster? What do you do with it?
The firearms we take it to we're in the process of, with our chief, getting it to Cartersville. There's a place in Cartersville that, does the destruction of firearms.
Okay, and what about all the ammunition?
We are also in the process with our chief, getting it, disposed of.
All right. Wow, some of this goes back to 2015. Is this the first time you've ever cleaned out the evidence room?
I just started, back in August of 2025. And so this is, I think, our third instruction order.
All right, well, you're making progress. You're getting closer to stuff that was seized this year. All right, well, good luck with it all. You too. Mr. Edge,
Sir.
couple questions for you, and then you can respond however else you want to the arguments Mr. Kenner made. Timing, let's put the shoe on the other foot. Why did we wait until just a few weeks ago as Harold's Chicken and Ice Bar Edgewood was starting to reopen to say, gosh, Judge, we need to get back in court for our preliminary injunction hearing? It's been months and months and months.
We were waiting for the court to add Harold's Ice Bar, right? And then remember around the same time at our last hearing, you said, hey guys, you all should mediate.
I did.
We reached out to the defendants and say, hey guys, you know, the costs are becoming more and more. Let's try to resolve it. Mr. Kenner and his client said, we're not mediating. We're not doing that. And we said, well, okay. I reached out to Miss Monica Niles, and I said, Miss Monica Niles, can we schedule a new hearing? And then I think she met with you. We got some dates. I tell her about the dates that I'm available. I don't think Mr. Kenner responded immediately. I think it took him maybe a couple of days, maybe a week or so to respond. And that's how we got here. So, Your Honor, we weren't just sitting on our hands. We were waiting for the necessary party. We couldn't move forward with our preliminary injunction hearing without Harold's Ice Bar.
So you moved in September, it looks like, to add, if that's what this motion is, to add Harold's Ice Bar.
Yes, sir.
And it took a few months for
Yes,
that
sir.
to happen. Well,
So we were
that's
waiting.
on me, sorry.
We were waiting. And then there were so many motions that were filed. It was almost like a motion war with Knox Withers and Kelsey O'Neill. I'm not sure if Mr. Kenner had filed as many motions, but we were responding to the motions. So that's what took up all the time. Okay. So again, like I said, with the conversation that I had with Mr. Kenner, we didn't know that they were about to open this restaurant. We were responding to these frivolous motions. So then I find out on Tuesday, as I'm about to get ready for bed, I see a flyer. I'm like, oh my gosh. So I'm up until the morning preparing this emergency motion, and then we filed it hours later. So that's what happened. That's how we got here. We weren't sitting on our hands. Also, Your Honor, Mr. Kenner pointed out that we've known all along that they're trying to open up this restaurant. He's right. That's why we filed this lawsuit. We're trying to stop them. We're trying to stop them from opening up this restaurant under the name Harold's Chicken and Ice Bar. And that leads to my next point, Your Honor. There are some things that Mr. Kenner said that I feel like were incorrect about some of the facts, about the disagreement between Ms. Robinson and Ms. Rutherford, but I won't bore the court with that. We can address that at another time. But something in particular that I felt like is necessary to speak about is about how Harold's Chicken and Ice Bar on Edgewood came about. For months, I had conversations with Ms. Christine Diane Pierce. And of course, some of that is hearsay, and I can't talk about the actual extent of the conversation, but I have a good understanding of how this thing came to be. I'm not sure if Mr. Kenner had talked to Ms. Christine Pierce. She was going to be our star witness, but for unfortunate reason, she's no longer here, so she can't tell her story. But she was up.
Or do you get to tell her story?
Can't tell her story, but I can tell the story of Harold's Chicken and Ice Bar. So there's a company, Harold's Chicken Shack Corporated. That's the parent company, and so
The parent of whom?
of the franchises of Harold's Chicken. So they are Harold's Chicken Shack, right?
Ms. Pierce's company.
Exactly. And so what happened is Bobby Robinson went to Ms. Pierce and essentially requested to open a franchise. And she told her that it's in the affidavit. It's in the affidavit.
Well, what's not in the affidavit is Ms. Pierce saying that she didn't allow Ms. Robinson to use the name.
Well, I'm going to ask, I'm about to get to that with Mr. Edge. So I'm going to let him keep going, but
And also, I would like to apologize to Mr. Kenner for interrupting earlier. It wasn't intentional outburst, but when I heard something, it was kind of shocking to the conscience and stuff. I was like, oh my gosh, I don't think that's correct. But nevertheless, I would like to apologize for form on my part, and I apologize for that.
Okay.
But what I would like to say is that the agreement was that they could open up a franchise in Atlanta. They had to pick a location. They had studies done. They found.
Your Honor, again, that's not in the affidavit. When he's testifying to.
What affidavit are we talking about?
No, it's not in the affidavit. It's in an article that they posted. It's here.
So he.
Okay, but let's not go off of what's in an article.
And it was attached to our amended supplemental brief for our.
Okay, that doesn't make it
but essentially
non-hearsay.
They picked the location. They told her where they were going to be. She granted them the opportunity to open up at that location.
Okay, all right, so stop objecting. Here's my question. What is your understanding about Ms. Robinson's ability to open up a Harold's Chicken and Ice Bar at 347 Edgewood? If she wanted to open up tomorrow, a Harold's Chicken and Ice Bar at 347 Edgewood, does she have that ability? Because she was given the rights, apparently not in writing. There's not a franchise agreement. I talk about a franchisor, but this was word of mouth handshake, and that's still an okay way to do business. It just makes it tricky come litigation time. What would prevent Ms. Robinson from opening Harold's Chicken and Ice Bar next door to this building?
Your Honor, I think the thing is that they came up with the name, the common law trademark name, Harold's Chicken and Ice Bar. Remember, I said it's Harold's Chicken Set.
Right.
Bobby Robinson and Taryn Rutherford. It's the name, Your Honor. It's the name Harold's Chicken and Ice Bar. It was not here before them. Okay. They created that name at 349. So they took the permission from Miss Pierce. They morphed the Harold's Chicken registered mark to Harold's Chicken and Ice Bar, which become through trade and usage, it became a mark of their own. Okay. So they used it for 349. So she owns that.
Okay.
But now if she opens, like you said, she opens at 347, then that could potentially cause a problem. Maybe. I'm not sure. I'm just looking at the 349 of where we at right now.
Well, but so you seem more focused on real estate than name. I'm trying to understand, because you don't trademark a piece of real estate. The trademark, insofar as it exists, relates to the name Harold's Chicken and Ice Bar and what that means. And I'm wrestling with the fact that your client and Ms. Robinson have other Harold Chicken and Ice Bar that the other has nothing to do with. Yeah. So let me just finish. Yes, sir. If Ms. Robinson wanted to drive into the ground, one of hers that's somewhere else, Ms. Rutherford couldn't say, you need to spend more money on this one because it's harming the trade name. This place is ratty. People get sick here. You're hurting my business because your Harold's isn't being run well.
The difference is, Your Honor, again, they created the name, right? It was birthed out of Edgewood. Edgewood was there for the longest. They had so much success.
And then it closed.
Later on. We're talking about maybe 13, 14 years.
But then it closed. It stopped being there.
But it closed for renovations, Your Honor. That's the thing that they're muddy in the ground.
Whose renovations?
The landlord. They were already planning to close the business for renovations. It was going to be renovated. That's been the discussion from the beginning. We're closing. Bobby Robinson, and it's shown in our complaint, told Taryn Rutherford, we're closing because we're cash poor. We can't do anything. But they were closing anyway. The building was going to be closed regardless for renovations. Right. Because they had took out a loan, and I think there were some loan requirements, and they had to get the renovations done. Okay. So basically, Bobby Robinson lied to Ms. Rutherford and said, we can't go on any longer, not because the business wasn't viable and couldn't go forward. It's because she didn't want to work with Taryn anymore. She wanted to work with Cameron Pym. And that's the conspiracy. Remember, Cameron Pym came to Taryn Rutherford. Taryn Rutherford didn't go to Cameron Pym. Cameron Pym came to Taryn Rutherford. They had an LOI, and then he revoked. And then he said, I'm not going to buy you out anymore. And then he went with Bobby Robinson, and then they started working together. And they essentially squeezed her out.
So yes or no, Ms. Robinson could open other Harold Chicken and Ice bars without requiring Ms. Rutherford to approve?
Your Honor, I'm going to say no because I'm going to look at the geography, right? We're on Edgewood. There's going to be confusion there, right? Right. If I come back, as my example earlier, if I come back 10 years later, I see two Harold's Ice Bar right next to each other, I'm definitely confused. So I think it's more of the proximity, the geography of the area. I think like in the case that I had earlier.
So let me ask it a different way. Let's say Ms. Robinson said, we got to close it. Your client walked away at some point for a little while, and I don't think that's
Like
in dispute. Okay, but she's out of it. And then Robinson walks away from it. And Tim says, well, I'm not getting anything out of either of these folks. I'm going to turn 349 into a FedEx store. And then Robinson says, you know what? I'm making some good money in my other places. I'm going to buy 347 Edgewood, and I'm going to make that a Harold's Chicken and Ice Bar. Why couldn't she do that?
Well, Your Honor, Bobby and Taryn had an informal agreement where we're going to say where we're going to have our locations. Before each of them opened up their locations, they had a conversation with each other. They just didn't just say, hey, boom, pop up one day, there's my location. They had conversations with one another so that they wouldn't impede on each other footprint. In a sense,
So
right?
Ms. Robinson wouldn't open one on Panola Road?
No, sir. They had an agreement.
That's not her turf. Okay.
So that was their agreement. And to your point earlier, right? Everything was birthed out of Edgewood. They had their own agreement with Miss Pierce. They opened up in these other areas, and they became successful. But the mothership, the flagship, is Edgewood, and we have articles to prove it.
So your client could testify to this, so I'm okay you answering it. Did Ms. Rutherford need to get Ms. Pierce's approval to open up Panola Road?
Yes.
Okay. And do you think that Ms. Robinson needed Ms. Pierce's approval to open up wherever she opened them?
To open up wherever she opened up? Yes, but not Edgewood, and it's in the affidavit.
Well, because Edgewood would have been where they opened first, so that's where Pierce would have said, here's where you're starting. But what you're telling me is each time they wanted to expand, they had to trot back to Ms. Pierce and say, hey, we're going to open another one. I know it's not Harold's Chicken Shack, but look, we're trading off the Harold's name. You got to start it on Edgewood. So if I, Ms. Rutherford, I'm going to open one on Panola Road, or I, Ms. Robinson, I'm going to open one wherever one is, Ms. Pierce had to give the green light.
Yes, sir. She gave the green light, and in the affidavit.
She's now deceased.
Yes,
so
sir.
where does Ms. Rutherford go if she wants to open up? Let's say Ms. Robinson says, I'm done with it. This litigation is costing too much. Fine. Pim and I, we're going somewhere else, and we're going to do a Harold's Chicken and Ice Bar because I have the same right you do to use a name, but I'm not doing 349. Could Ms. Rutherford say, all right, I'm going to slide into 349 and I'm going to reopen Harold's Chicken and Ice Bar there?
I think to your hypothetical, if Miss Rutherford wanted to go into 349 and open up a new Harold's Chicken and Ice Bar, she would have to get permission from Miss Pierce.
Well, it can't happen anymore.
Right, can't happen anymore. So
that's
whoever's running the company, she get permission from there. And then because of the common law trademark, she would have to get permission from Bobby Robinson. That's what I said earlier. Neither one of them can go in and say, I'm going to run this without the express consent of the other, because the company was dissolved. They each own a half of the trademark of the name Harold's Chicken and Ice Bar, because they are the authors of that name.
What would you point to that would obligate either your client or Ms. Robinson to consult with the successor in interest to Ms. Pierce to open up another Harold's Chicken and Ice Bar? Because it sounds like it was an informal arrangement. What would Ms. Pierce's successor in interest invoke to prevent either your client or Ms. Robinson from opening up another, again, not Harold's Chicken Shack, but Harold's Chicken and Ice Bar? They decide to go north, Alpharetta, it needs one. So Ms. Robinson says, I'm gonna open one. I know you're not the lawyer for Ms. Pierce's estate or whatever succeeded that, but what makes you think that they have to go back?
I think because of the name Harold's Chicken, right, to use that, Harold's Chicken, they would have to get permission. But the ice bar, part of Harold's Chicken Ice Bar, belongs to Taryn Rutherford and Bobby Robinson. I mean, it belongs to them. They created it.
I'm not disagreeing with you. You're not, I'm trying to understand what would the mechanism would be to open another one, and why you think that Chicago would have to approve of it.
Because of the Harold's Chicken. And it says it in the affidavit that Cameron Pym, Bobby Robinson did not get my approval to operate the franchise at the location.
This is Ms. Pierce's affidavit.
Yes, sir.
Okay.
It's in the record.
Okay. All right. What else did you want to add?
Your Honor, as I said, the harm is clear. Opening of this restaurant for the preliminary injunction hearing is the epitome of bad faith. It is harmful to Ms. Rutherford. It's harmful to her right to the use of the name at the Edgewood location. This has been, she has had this right since the beginning, since they started. And the defendants are essentially trying to steal that away from her. And damages can't resolve this harm. What can resolve this harm is that we enjoin the defendants from continuing to operate the business until Tuesday, to stop advertising the opening of the franchise until Tuesday. And so that we can move forward with this preliminary injunction, so that the court can hear testimony from the witnesses, so that you can rule on the merits of our motion. And we're just asking, I mean, this is a narrow set of relief here, right? We're not asking for them to, stop spending money, to bring back the chairs, right? Like you said, that's monetary damages. A trademark trade name, money can't cure that. Money can't cure loss of goodwill, reputation. Money can't cure that. So we're asking that you prevent them from moving forward, and that you give us the opportunity to move forward on Tuesday so that the court can make a ruling on the merits.
What about the public's interest? That's one of the things I need to weigh.
Yes,
And
sir.
if there is a lot of public excitement about getting back in that building and eating and drinking and smoking, how do you balance the public's interest?
Well, Your
You'll
Honor,
be taking away from them an entertainment opportunity over the next few days, and I don't know what you'd give them in return.
well, essentially, it would be, if we allow them to move forward, it will mislead patrons into believing that the defendant's business is affiliated with Ms. Rutherford.
What is you may consume more reality TV than I do.
I really don't.
Okay. But I don't either, but I'm remembering some more about our hearing from way back when. It sounds like amongst some groups who would be excited about, inclined to go back to Harold's, there's not a whole lot of confusion that there was an ugly, messy, throw it all down breakup, and there hasn't been any making up since then. And we can't quantify any of this. I get it, but you're asking me to assume that it goes poorly, and so that has harm to your client. And there would be harm to your client if, number one, the 2.0 goes poorly, and people still associate your client with it. You may have a little more traction with number two because of your affidavit, but it's also clear that there are a lot of people out there who know that Robinson and Rutherford do not like each other, and they're not going to have a joint venture. So how do you weave that in? I mean, you don't just ignore it.
Well, Your Honor, just because Mr. Kenner says that some people know. That doesn't mean everybody knows.
No, but that's not the standard. It doesn't need to be 100% penetration. There may be 5 people out of 100 who go in there and say, wait, I don't like this place. I'm so mad at Rutherford. She had it. And there may be 95 people who go in there if it's a bad experience and say, I knew this wasn't going to be good because she kicked Rutherford out.
Your Honor, there's been tension between Ms. Rutherford and Ms. Robinson since the genesis of, I mean, that's how it is. And for most successful businesses, you see most successful teams, you know, there's friction, but somehow success and achievement is birthed out of that. And that's what happened here. But just because the world hears that, or some of the world hear that Bobby and Taryn had a disagreement, I mean, that doesn't cure the harm. That doesn't cure the harm because, like I said, for the people that don't watch reality TV, the people that are not privy of their relationship, when they step foot at 349 and when they see the same sign, they see the same menu, they see the same everything, the identical business, they're going to be confused. And then it opens the door for harm. The horses will be out of the barn, Your Honor, and it's hard to be able to get them back in. And that's why we need this TRO.
Is there not harm through the TRO if this place is shuttered and people think, gosh, Rutherford can't figure out how to get it right? They opened it. It was open for a few years. It was amazing. And then it got shut. And then they reopened it for like 4 days. What's Rutherford's problem? She can't figure out how to run a business.
Right. So it would be harm to both. It would be harmful to plaintiff and it would be harmful to the business. But the problem is with the business, that would be self-inflicted. No one told them to open this business days before. I
got that. You told me that before. If it ends up being that Harold's Ice Bar Inc. stubs its toe because they did something they shouldn't, but I'm curious why you aren't flagging, well, you know, actually having it shut after the grand opening and there's media coverage. You're saying that it's going to be real hard for people to disassociate your client from the 349 Edgewood address. And if it has this false start and close, why is that not going to be a problem for your client?
Your Honor, because that is a harm that they created and that.
Well, but they create the harm if it opens, stays open, and is a flop. 100% their creation, bad news for your client. It's also a flop if I close it right now and say you can't go further. What was it? The inspectors? Was it mob money? Why did it go nowhere? What's Rutherford up to this time?
But Your Honor, essentially, they will, in a sense, be forcing your hand to open because they rushed to open. Right? Like that's what happened. They rushed to open and now it makes it difficult for you to make the decision because we have to think about the what ifs. But had they only waited until the 19th, we wouldn't have to have this conversation. We wouldn't have to deal with this hypothetical. Had they only waited, but they rushed to open. They tried to alter the status quo.
Do you have any evidence? I know there's been no discovery, but I'm curious about your use of the verb rush. As Mr. Kenner pointed out, they didn't rehab and refurb this place over the last week. Of course, this hearing only got set a little while ago. Not today's hearing, next week's hearing. You pointed out, I've been looking for this for a while. And so the notice of hearing was April 17th was when it was entered. So before that date, I mean, you two may have learned about it because Ms. Niles may have been asking you about your schedules. We're not always that polite. But at the latest, April 17th, do you have any evidence that from April 17th to last week's soft opening, this weekend's hard opening, that they're like, we got to triple our, like they're doing for the World Cup. Faster, build faster.
Your Honor, we sent them discovery. We would have had access to that information. They withheld the responses and the documents. It's like we're being punished for them abusing the litigation and the discovery process.
Asked you if you had a basis to say rushed.
No, and Your Honor, the discovery we sent them was detailed. I mean, it was extensive. We asked all of the right questions to get what we needed, and they withheld it. Then they filed this motion to stay, basically saying discovery is stayed because there's a pending preliminary injunction motion that the law does not support. The law, I mean, if there's a pending motion, preliminary injunction motion, that doesn't stay discovery, right? And it said that it would cause harm because this was a part of their scheme and their plan, Your Honor. Tried to force the court's hand, and they tried to withhold documents from us so that we could prove our case.
Can I respond to some things? I know he gets the last word, but.
Maybe. Let me just talk about a couple other things, and then if you feel like you need to, that's fine. So, Mr. Edge, one more question,
Yes,
and
sir.
then I want to talk a little bit about discovery and the motion to dismiss. And then if there's still something, Mr. Kenner, you want to share, you can let me know. I feel like the first I heard about you not getting discovery was kind of today, and I'm not remembering, it may have been in your brief as well. If you felt like you were not getting the traction you should be, and you started to feel a sense of urgency about it, why didn't you reach out?
Your Honor, so discovery was sent in March, right? 30 days is April.
Yep.
All of this happened around the same time. We had a call with Mr. Kenner.
You mentioned
right?
you call it sort of a 6.4 call.
Yeah. But we discussed discovery, and we were saying that we expected discovery. Then there was this conversation about, well, is discovery stayed or not? Judge never ruled on the motion to dismiss that was filed by Arnold, Golden, Gregory. And so is discovery stayed? It was filed before the answer. Well, then there was the motion to add. Well, did that moot the motion? And then Mr. Kenner was like, well, I think discovery stayed because there was the motion for preliminary injunction. And so we were talking about it and trying to like hash it out. And so, but our position was that discovery was not stayed. And so we told him that we expected to get the responses, and all of that fell around the same time.
Okay. The motion to dismiss, if it's granted, would be in part only. There are some counts that I believe very clearly survive the motion to dismiss, which means discovery needs to start, and it needs to start with some speed. And so I said it was last question. Now it's really the last question for right now, Mr. Edge. Sometimes you give good answers and it leads to more questions. Do you want some discovery before we have next week's hearing? Do you think that you would have better traction with that hearing if you got?
Certainly, Your Honor. Certainly.
I guess you should wait to answer that till I end up ultimately ruling on your emergency motion.
Yes, sir.
And you'll have to figure out how you want to strike the balance of, if the emergency motion is denied, then do you want to hurry up and have the preliminary injunction, or do you or do you want to? I probably would require some of the discovery to be produced in the less than 30-day window. I'd probably invite you to send me as well the discovery request so that I could say, hey, request for production 1, 9, and 14, you got 10 days for those. And you could push back, like, that's insane, Judge. But there's some things, in particular, like access to records and whatnot. I appreciate that's one of your counts. But there are certain things that, one, should be super easy to produce, and two, are undoubtedly just burning a hole in your litigation book. Like, if I could just get these things, it would be a whole lot easier to support the claims that I advance in my complaint. And I'm not pointing fingers at either of you. It has been a fluid docket. There's been churn because there've been a bunch of versions of the complaint. There was some confusion because a firm withdraws, we add parties, et cetera. But it is clear to me that what won't be going away is the core dispute of did Ms. Rutherford abandon, or was her stake taken? That's not going away. That has to be litigated. And so discovery needs to start flowing. Some of the other things, they're more sophisticated than that. And so I need to think about them more. And obviously, you all will want to get some discovery to push in that direction. And so what I want flowing out of today in part is some thoughts from you all about how to turbocharge discovery, not in the sense that you haven't asked for it, but I'm not taking sides on the was discovery stayed or not. I am acknowledging that the docket is a peculiar one because of the ebb and flow of things and again, multiple versions of the complaint followed by multiple motions to dismiss. But it's time because there isn't a reason to dismiss, I think, that's been identified. All the counts, maybe some, maybe none, but because some will clearly survive, discovery really needs to get going.
Yeah, Your Honor, and I mean, that's a tough question to answer, right? Do we allow them to remain open for
Well,
30
I'm not
days?
asking you to decide. I'll decide
Oh,
that
okay.
part.
I thought you were asking me.
No. I'm going to rule on your motion
Yes, sir.
about the emergency equitable relief. And you may want to wait to get that ruling before you say, I don't want to move the preliminary injunction hearing, or regardless of that, Judge, I do want to move it because if you can ensure that I get some of this discovery in the next 15, 20 days, we could have a much more robust preliminary injunction hearing because it would move beyond the, well, my remembrance is this or that, and you'd be saying, well, but look at these records here. It may be that the records go more to the damages that would flow if a fact finder concluded that it was a theft of a stake in the business as opposed to an abandonment of it.
Okay.
I'm not managing how you do all that, but I do want to. We've been stuck for a while, and I want to unstick the case because it isn't going to go away through a motion to dismiss. It may become a little more streamlined, but that core piece is going to keep moving forward.
Right.
And I appreciate time is of the essence if in the end my ruling is the restaurant stays open, because that only increases the risk if the restaurant is not a critical success to the kinds of damages you described that would flow towards Ms. Rutherford.
Yes, sir. So I guess whenever you rule on the motion, how soon should we give you a response about if we want to keep May 19th or if we want to push it back to
Well, the tricky part is May 19th is 4 days from now.
Yeah.
So it would need to be before then. That's all I can tell you is that I'll figure out, I need to do a little reading.
Yes, sir.
And then what will happen is I'll get Ms. Niles to send you all an email that says denied or granted the emergency TRO. We'll get something in writing ultimately in the docket, but there's some important planning that the defendants would need to do. If it's granted, they have to tap the brakes.
Right.
If it's denied, then they don't tap the brakes, and maybe it's partially granted and you stop advertising on social media, but it's open and you're going to do what you do. Either way, I'm going to let you digest it, but it would be at some point before we'd start, because I don't want to make you all come down here on the 19th to only tell me, yep, we'd like to have 20 days of discovery. You could do that by email and then you don't have to be here. But you'll have as much time as you want. You could wait and say, I need more time to think about it. And then just let Mr. Kenner know that the 19th isn't a hearing. It's could we just talk about the mechanics of how discovery would flow? You have a big chunk of my time on the 19th. And so if that's what you want to pivot to, because you want to defer the preliminary injunction hearing, then it could be a discussion about, yep, those discovery requests are ones where I'm going to say you got 10 days to do it. And you'd be right here to say, let me tell you why that couldn't work, because the accountant is in California or I've got leave or whatever. And I say, okay, you have 11 days.
Well,
In a minute. So I'm not trying to be vague or confusing, but because I intend to make discovery start going, I just wonder if that would be the kind of thing you'd want some before you do the rest of the preliminary injunction here.
understand, Your Honor.
You can think about it. You don't need to commit now.
Yes, sir.
Be thinking about it.
Yes, sir.
All right. Mr. Kenner.
yes, Your Honor, and I know we've been at it for a while now. But
It's all right.
I would like discovery to start as well. We set the plaintiff some discovery.
Two-way street. If discovery is going to be flowing from your clients and you've got requests, we'd have the same dialogue. If it's going to be on an expedited basis, you need to identify which things that you would be valuable to get if the decision is to defer the preliminary injunction hearing. And I think that's a Mr. Edge decision, not yours. If he says, you know what, I want some time to do that. If he says, I want 60 days, then I don't need to get in the middle of discovery because whatever's been propounded, you got 30 days to respond. But if he says, you know, could we do it in 20 days? Because, you know, you didn't close the business down. They're not allowed to advertise for it, but the store is open. So I don't want to push it too far out because of the risks that he's described. And that's why you're going to need to think about it. You're going to need to talk with your client about what makes the most sense. But yes, discovery in both directions.
How extensive will discovery be? Because will we be allowed to take depositions and things?
That's what we need to talk about. And it may be that you say, I got 14 depositions I want to do. And I say, okay, which is the most important one if it's going to be before, again, this is all if it's going to be before the hearing. If it's not going to be before the hearing, then I'll see you all on the 19th and we'll have the hearing. But if we're moving the hearing out some, then I think it would behoove us to have a discussion, again, unless that's being moved so far out that you could do most of discovery. I hadn't thought about depositions because that's not always just 30 days because people's schedules are complicated. We have successful business women here. They don't just like, I'm free every day. They have things they're doing. So we might need to strategize on that one where some of your desired depositions would be put in the category of that can wait and you're entitled to it. Discovery lasts 6 months. But these are the ones that we put up at the front and I might need to lean on a few people to say, let's make this happen.
And the other thing, Your Honor, as it relates to the inspection reports, things of the nature, business records, they have access to it because I believe that is Ms. Rutherford's accountant. She still uses that accountant to this day for her own business, as well as my client as well. So my client doesn't have access to these records because the accountant has access to the same records that they're trying to get.
Well, Your Honor, I've reached out to.
I'm assuming that's not accurate or we wouldn't keep seeing that.
Your Honor, I've sent requests to Mr. Betts, named Stephen Betts. We sent him third-party requests. When after Miss Bobby and
So what does he say? You sent requests. What is his response?
I haven't
No
heard
response?
anything from him.
Okay.
No response.
All right, well, now is the time to start invoking me. And so if we need to send an order to Mr. Betts, so he comes to court with the records on a thumb drive, I'm happy to do that. You shouldn't have to knock on that door more than a couple times. So you're both correct. It sounds like Mr. Betts has them, but he's not coughing them up. Now, if he comes in here and says, I didn't give them because Robinson said I better not or I'm in trouble.
That's what I think that happened.
Okay, but he needs to say that. And if he says that, then Ms. Robinson has some things to explain. But right now, he just isn't getting back to you, and he needs to. And it may be that's part of discovery too, where he needs to explain, why'd you ignore this stuff?
Your Honor, the accountant is still her accountant to this day. So why would he allow Ms. Robinson to tell him don't give him the records? That makes absolutely.
Maybe she pays a higher hourly rate. I don't know. I'm not saying she did. Mr. Edge did, but it's peculiar that he wouldn't hand the stuff over. And who knows what he was.
He just doesn't want to get involved. I don't know.
Could be. He doesn't have that freedom.
The other thing I wanted to correct, Your Honor, is that counsel accused us of not wanting to mediate. The issue was that I asked counsel, well, can you give us an offer to start the conversation? Give us an offer. What are you asking for? And he said, well, we want to do discovery first. And I said, well, we don't really need to do discovery to give us an offer because that will let my client know whether they want to, you know, settle this case for that number or what.
Well, I think mediation will be much more productive after some discovery so that Ms. Rutherford and her lawyer could see what's been spent, what might be earned. I mean, you start to get some data points as to what the perceived value of this resource is, et cetera. So I understand why someone wouldn't want, I mean, you're sort of betting against yourself, like, well, I have no visibility right now because the accountant, for whatever reason, sharing stuff into what's going on. And so I'm going to bet blindly and I might leave a zero off where I could be going.
I just want to correct that.
We explained that to
I just want to correct the assertion that I said, well, we're not mediating at all. Because that's not how.
You were just ready to go in a different posture than Mr. Edge was ready to go. I see both views, so we don't need to have a back and forth about it. Okay, we don't need to, bottom line is mediation didn't happen. Another reason to get discovery flowing, because I think that'll make it more likely that it could happen.
Yeah, Matt asked, we had emails about the mediation. And then during our call, we're talking about discovery. Mr. Kenner said, my clients are not, if your client's looking for money, my clients aren't paying you anything. He said that. He said that.
Okay. All right. I wasn't there, and you guys are doing a great job of preparing me with the family division, which is where I'm heading, regrettably. And I am told that this is a lot of how it flows, which is too bad.
The last thing, and I promise I'll be quiet. The motion to dismiss, like how, because my position is without an order on a motion to dismiss, at least partially, some of the counts. I think if we start discovery before we get the motion, the order on that, then we're just expending time unnecessarily trying to discover certain things that are certain evidence that we really don't need because that count may have been dismissed or what. So.
Well, this is not the formal order, but just to give you a flavor, counts 1 through 5 are alive and well. They are pled against Ms. Robinson and Ms. Robinson only, and that's fine. That doesn't make them dismissible. If they're not, if count 1 isn't against E3 or Mr. Pym, because you've got all these as your clients, then those two don't need to worry about it so much. But your motion says you need to dismiss some of these counts against these other people, but they're not dismissible against them. Counts 1 through 5 are all against Ms. Robinson only. So,
well, the only reason I said that in my motion is because I want to make sure that the court says, okay, in other words, so plaintiff then come back and say, oh, well, we inferred, E23 as well as Mr. Pym in 1 through 5.
Okay, and that may have been part of why the Fourth Amendment amended complaint came around, where it was, I don't remember if the third one was as explicit, but the Fourth Amendment complaint, it says, count 1, Robinson only. I mean, it's right there in Technicolor, so there's not confusion.
We've always designated what parties the claims were being asserted against.
So that didn't change.
Because we couldn't have a claim for inspection of corporate records against Cameron Pym.
I got it.
He wasn't a party of the original agreement.
Anyway, I'll work through the other parts of the motion to dismiss, but that was just an example that, for example, 1 through 5, they're alive and well. And discovery that is focused on the nature of the arrangements and negotiations and communications between Ms. Robinson and E32 and Pym, that's all squarely within claims that Ms. Rutherford has just against Ms. Robinson. Say nothing of conspiracy and Pym and E32. I'm getting the sense that some of those will survive as well, but they'd be something that Ms. Rutherford would be entitled to get just counts 1 through 5. So I don't know. I haven't looked at any of the discovery requests, but so much of it drives through counts 1 through 5. I don't know that there'd be too many requests that Mr. Edge would have where you'd say that only relates to count 19, and this is the funky one, and it's not clear, third party doctrine. So I don't know that there'd be too much wheel spinning on your part responding to discovery. But again, if we end up next week talking more about what's a way to get some discovery done real quickly, that's where you could say, well, really help me know if count 14 survives. Because if it doesn't, then 12 of his discovery requests, I don't need to spend time on. I don't mean to do that to either side, to make you produce discovery for something that's not going anywhere.
That was my concern.
Okay, fair concern. Mr. Edge, anything else on behalf of your client?
No, sir.
How you doing, Ms. Rutherford? What are you going to do this weekend? Breathe. Do a lot of that. All right. I think that's it. Ms. Niles will get an email out to you all before the day is done, letting you know how this weekend's going to go. Then Mr. Edge, you can be thinking about what that means in terms of, do we still meet on Tuesday? Could it be a Zoom communication? If it's just going to be, how do we structure discovery, or do we use Tuesday as originally intended? Does that work? Mr. Kenner, anything else?
Right.
All right, we have had Ms. Kirkland dutifully taking all this down. You all will make sure she's compensated?
Yes.
Yes, sir.
Okay,
Yeah, we're gonna share and take.
you're gonna share in that. Okay, Ms. Kirkland, do you need anything else from us?
No, I don't, Your Honor. Thank you so much. I will have Gala reach out to counsel.
Okay, sounds good. I think that's it then. Appreciate everyone's time.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Have a good weekend.
You
Your
too.
Honor, well.
Do you need this to be on the record, or
I'm sorry.
are we on the record?
Yes, we are. I did ask
Okay.
for attorney fees. I didn't go into that.
Okay, you did. You've preserved it.